Representative.
Thank you, Mr. Chairman. One more question. Breathe a little life into your third bullet point in terms of prohibiting lenders from charging a fee to broker loans from another organization. And the second part I get a little more in terms of the credit service organization, but maybe give us a little description as a practical matter, how they're operating and what it is that you're trying to curtail.
Through you, Vice Chairman, to Representative Bacon. The brokering concern is that third bullet point is really to close what we believe could be future loopholes. One example, in the state of West Virginia, they prohibit payday lending altogether. In that state, there were lenders that popped up that were actually brokering loans for a company out of North Dakota, I believe it was. That case actually went to the state Supreme Court in West Virginia and was upheld as the right decision to make sure that they had to close down because the law said that they couldn't in fact do that. The CSO, what we're finding out through the CSO, the credit service organizations in the state of Texas, payday lenders had moved over to that program. In the state of Ohio, it's important to note that under the credit service organization statute, that really there's no specified terms concerning what those fees can be. It's my understanding that there are 8 current applications under the CSO statute and that there have been 8 additional applications. But through those examples of what's taken place, the feeling is that that would be the next area to migrate to. So in other words, if you wanted to migrate away from SLA and OMLA, you could then migrate over to the CSO.
I believe Representative Hackett.
Thank you, Mr. Vice Chairman. Thank you, Representative. And I appreciate, that this has been a long process, and we worked very hard on this, and we're coming closer. And I'm going to talk a little what Kevin, Representative Bacon said. When you first look at this, I mean, the only thing that I wish we're not talking with that industry with a point to understand how this fits their business model. And I know you quoted figures, but we always quote figures, we're almost like markers. You quoted a figure, $30 cheap, for it's not at 500, it's 501, and that's where the highest interest rate is. And so if we did a $15 fee at 500, what would that interest rate be? And we all know, I mean, the consumers, we all know that when you pay something in a short period of time, you're going to have an exorbitant interest rate. So my only concern is that, are we talking at all with this industry to see if it fits in their business model? There was a lot of abuse in this industry. I mean, at the first event, we saw that through these hearings, and you've done a good job. But remember, what we're trying to protect is, we don't want to run these companies. I can tell you as a financial planner, there's a distinct need for people to have access to debt. And are we going to run an industry out of business? Because when you look at the actual dollars and the time involved, can it work in a business model? So, I mean, the question is, why are we not talking to the industry and talking about their business model? When you did this, because you didn't come, you came from 6 months to 90 days, and they're right now at 2 weeks. And so we're between 2 weeks and 90 days. Is there some type of give and take between the 90 days and the 2 weeks where they can come in and add fee? Because we agree, get rid of the check cashing fee, but we all know we need to approve a fee and we need to approve an interest rate.
Through you, Vice Chairman Skindell, the Representative Hackett, we have had discussions with them regarding payday legislation. And I can tell you that they have been very clear, and they've said it in previous committees, that they need the check cashing fee. They've made that very clear. They have made no excuses for it. I'm sure when they come in to testify, there won't be any apologies. They'll make it very clear that they need the check cashing fee. And that's obviously an area of disagreement, because we believe that check cashing fee shouldn't be charged, especially for an industry that used to provide you with cash, instead of giving you the check and then charging you the fee on top of it. Through this process, we try to be very sensitive to the fact that legislators have said that this is a resource that needs to be available. We have lenders in Ohio that operate under SLA, that operate under OMLA. They seem to be finding a way to pay their bills by doing those loans. So this industry wants to be able to charge some additional fees. And I guess it always comes down to, it's similar to when we were doing the energy bill, trying to determine, what's profit, what's excessive profit, those types of things, and where you draw that line in the sand. When the industry comes in to testify, I'm sure they'll be giving you some benchmarks as to what they think they need to make per loan to be able to pay their bills. And I'd be willing to bet that it's a little bit higher than what other lenders are able to do under these statutes.
Just one thought. You didn't consider a 60 or 30-day period, as the period to reinitiate the fee because of that? I mean, just when you look at a $500 to $750 loan and the process starts over, and I realize it'll probably be a little quicker process, but how can they make money in a 2-week period with only 28% interest? How can they do that?
Through you, Vice Chairman Skindell, to Representative Hackett, we looked at the 90-day window from the standpoint of, the feeling was that if the 30-day window was done, then the loan would be issued for 31 days as an effort to move beyond what the law would state. And then if you did 60 days, you do 61. Remember, these are unsecured loans, and I think that there probably would be a great deal of discomfort if you had to go beyond 90 days on an unsecured loan. So, we had conversations with other parties about that and how we arrived at the 90 days. But if we would have done 30, then the industry would have been lending at 31. If we would have done 60, it would have been 61. But we thought that 90 days was a threshold where an unsecured loan, the lender would not be interested in going beyond that.
Thank you.
I believe Representative Height had a question.
Yes, thank you, Mr. Chairman, and through you to the witnesses. Just from the impact aspect of all of this legislation, in the last G8, we heard there were more payday lending institutions than there were, I think, Wendy's and McDonald's put together. In my travels in the area, I've noticed there have been a lot of closed entities, and I wondered, are we at the McDonald's level now? Do you know how many, by any chance, lending institutions have been closed down because of what we did with 545, by any chance?
Through you, Vice Chairman, Representative Height, I think I remember the original numbers were somewhere up over 1,200, 1,300. All I can give you right now is, if you talk to the industry will tell you that the payday industry no longer exists because they did not transfer over to the short-term lender law, which was created under 545. No one was flocking there to take out a license. So the migration that took place to SLA with the Small Loan Act and then the Ohio Mortgage Loan Act, the OMLA, I can tell you that the totals, companies that are now operating under those programs total around 969. And if you would like, we could probably get more information from Commerce, maybe as to who previously was a payday lender, but they were supposed to be set up under the short-term lender law created by 545. That didn't happen. So now they're operating in statutes. And we want to be fair to the Ohio businesses that have operated under these statutes for a long time. They obviously have a right to be concerned because they've said, we follow the statute, we follow the law. And now there's another industry or business that's chosen to come into our backyard to do business. And so why should we, be subjected to anything that's very restrictive? And we try to be extremely sensitive to that concern because it's not fair for there to be additional restrictions on them. At the same time, this is where the industry is now operating. So that's why we're trying to stick with the, if you look at the terms of the SLA and the OMLA, as I said, the origination fee, $15 up to $500. At 501, it goes to 30. Under SLA, if you have your license, it's 28% interest. Under OMLA, it's 25% interest. Under OMLA, you get to add on the credit investigation fee of $10. So we left all that. That's all the same. That's all the same. But as I said, we're trying to be fair to those businesses that are already under this statute, these statutes.
And follow up, Mr. Representative.